The Second Amendment is an important and fascinating amendment for a number of reasons. One of them is that it was adopted all the way back with the original Bill of Rights in 1791, but was not significantly interpreted by the United States Supreme Court until 2008. That's just a few years ago. What was up with that? Well, there were all sorts of reasons it didn't get to the court before then. But what's important is that the court considered what most people consider to be sort of the core issue. Is this a collective right involving militias, or is it an individual right to keep and bear arms? And the text of the amendment itself is deceptively short. A well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Do you read those two clauses together, or do you read them somewhat separately? Well, the court, by a 5-4 decision, by a very closely divided court, decided it was going to read them separately. The militia part of it certainly exists, you can't ignore it, but is considered to be somewhat anachronistic. I mean, we no longer have militias composed of farmers with flintlocks. The court in Heller resolved this question in favor of an individual right to keep and bear arms. And it did so for reasons entirely independent of militia service. It said, I believe I'm almost quoting here, that you have the right to keep and bear arms in case of confrontation. That is, in case a bad guy bothers you or bothers your family, and you have the right, essentially it's an extension of the common law right to defend oneself. That was a landmark case, a watershed case, but it did not answer all the questions.
The Second Amendment is a very interesting case of how constitutional rights can evolve over time. Originally, it was understood to prevent the federal government from meddling in state militias. In the early days, every male of fighting age was considered a member of the militia, and they were supposed to have a weapon ready to fight at any moment's notice. And the Constitution, the Second Amendment, was designed to prevent the federal government from intervening in that. And several times over the course of the centuries, the Supreme Court pronounced that there was no individual right to bear arms. In an important case in the 1870s, the Supreme Court said it as clear as day. The Second Amendment does not give anyone the right individually to bear arms. It's really only about keeping the federal government away from the state militias. And any right that there might be in the Second Amendment certainly didn't apply against the state governments. The right was actually designed to protect the state governments.
Now, the history of the Second Amendment is among the most debatable because everybody has an opinion on it. So I'll simply mention what the court has said. What the court has said is that although certainly the militia aspect of the Second Amendment is important, it is not directly tied to the individual right to own a gun, to keep and bear arms. In fact, they refer to that first part of the Second Amendment, a well-regulated militia being necessary to the security of a free state. They refer to that as a prefatory clause. And then they refer to the last part of it, the right of the people to keep and bear arms shall not be infringed, as the operative clause. And we can debate the grammar, and we can debate the grammar rules of that time, but the court essentially has decided the two things can be separated.
Although the courts have recognized the right to bear arms, they haven't said that it's absolute. In fact, the courts have given very little guidance on exactly what kind of regulations are still allowed. So, for example, is it constitutional to prevent someone from having a concealed weapon in public, or is it constitutional to prevent someone from having an openly displayed weapon in public? Those are the kinds of questions that are going to be working their way through the courts over the course of the next several decades. And it's very unclear how all of that's going to be resolved. So in the meanwhile, local governments, especially cities that are concerned about the proliferation of violence, are in a difficult situation of figuring out just how far they can go with their regulations on weapons. And the police are in the situation of having to sometimes interpret vague restrictions and apply them in a way where they might be concerned with, on the one hand, their safety and the safety of the community, on the other hand, with violating people's rights.
I can only imagine how disturbing it might be for someone in law enforcement. I mean, cops are, many of them, accustomed to being the only person who actually is openly carrying a weapon, and yet there they confront someone with another weapon that might be as big and powerful and destructive as the ones that they carry. And since law enforcement officers have the responsibility of keeping public order, that's got to be of concern. And yet, The court's been very clear that people do have a constitutional right to keep and bear arms, and that's what they're doing. Now, of course, that's subject to the local laws that are applicable, and so it might be entirely appropriate, depending upon the jurisdiction, for the police to ask to see a permit or to simply speak to the person in question and make sure that everything's on the up and up. But there can't be a presumption that this person shouldn't have the weapon. And that can occur, of course, in a traffic stop. It can occur in a number of different places. And I think that's probably the most significant aspect of Heller, is that from this point forward, for at least from 2008 forward, it's very clear. People do have a constitutional right, and the cops simply can't, as a default sort of perspective, think, I'm going to take that weapon from that guy.